Honors, the matter before the court this morning is the case entitled State of Vermont versus Justin O'Grady, case number 24AP182. Representing the appellant, Justin O'Grady, is attorney Chris Davis. Representing the Appellee, State of Vermont, is attorney Darren Raleigh.
Thank you very much, and good morning, counsel. Good morning, everybody. We'll hear from counsel for the appellant. First, of course, please introduce yourself, identify your client, and then proceed.
Morning, Your Honors. May it please the court. My name is Chris Davis. I represent the appellant, Justin O'Grady. In this case, this court should reverse the trial court's decision granting the state's motion to hold Mr. O'Grady without bail pursuant to 13 VSA 7553 and release him on conditions of release. And there are two grounds for reversal here. First, the trial court's decision was arbitrary. And second, we submit a clearly unreasonable exercise of discretion in light of the evidence presented at the weight of the evidence hearing. And what we're asking the court to focus on when we discuss the trial court's decision is the conclusion that Mr. O'Grady failed to meet his burden to overcome the presumption of incarceration. We know that in the 7553 analysis, if the state is able to meet its burden regarding weight of the evidence on a life offense charge, the presumption is pretrial incarceration and the burden shifts to the defendant to overcome that presumption. In this case, weight of the evidence is not at issue. We conceded that the sworn statements of the complaining witness met the elements of the sex assault charge.
Mr. Davis, I'm sorry to interrupt you, but there's 11 pending counts against Mr. O'Grady, correct? Or 12?
12, Judge.
And and one of the counts has a mandatory, upon a conviction, has a mandatory life sentence, correct?
Correct.
The sexual assault case. So so when you say that the court abused its discretion, the court made specific findings regarding what the charge was, analyzing the circumstances and the like. And how does that rise to an abuse of discretion?
It rises to abuse of discretion in this case, Your Honor, because the conclusion, which was never explicitly stated, but is implicit in the court's decision to grant the motion, is that Mr. O'Grady failed to meet his burden that shifted to him once the state was able to establish weight. And that conclusion is not supported by findings in this decision. The trial court correctly articulated that it needed to identify legitimate government interest in pretrial detention and conclude that holding Mr. O'Grady without bail would reasonably serve the interest of mitigating risk of flight and danger to the public. Those things will be true to some degree in every 7553 analysis, but just stopping there, as we submit the trial court did in this case, is an arbitrary exercise of discretion. If that was the end of the inquiry, there would be no reason for the burden shifting to the defense to overcome the presumption of pretrial incarceration. Here, the court, by granting the state's motion, concluded that we failed to meet our burden, but didn't articulate why. Why, in this case, with a defendant with no prior record, who served honorably in the military for over a decade, who has a career job in the county where he was born and raised, why was a release plan that provided for essentially round-the-clock eyes-on supervision outside the public workplace, along with a host of other protective conditions, insufficient to overcome the presumption of pretrial incarceration? The court made no findings about that. The only articulation of why our proposed plan was insufficient was the trial court's observation that the credible commitment to call police in the event of a violation of conditions is no prophylactic to the defendant's demonstrated dangerousness outlined above.
Mr.
Without
Davis,
the why.
I'm sorry to interrupt you. You mentioned in your just now and also in your brief that your client has no criminal record and a whole host of things that the court recognized would be in his favor. One of those things that you argue is that this was a very short period of time and something that was, unusual for your client to participate in, meaning the charges here. But isn't it even more alarming that, in fact, and making him more dangerous, that in fact this all of a sudden happened, rather than it being, something that happened 1 month and not again till 6 months later? I mean, couldn't the court have realized that just this change in his behavior in itself was more of a danger to the public?
I would answer that, Your Honor, by pointing to something that I raised in the second argument regarding why we believe this was clearly unreasonable, and that's a recognition of the timeline in this case, the timeline whereby the initial allegations of physical violence were brought forward in a May 4th RFA emergency filing. There were subsequently evidentiary hearings held, I believe, on May 24th and June 7th. Where both parties were represented in the family court by counsel. Testimony of both parties was taken by the complaining witness over the course of both days. And then a week after that, on the 14th, the final order issued. On the 15th is when this allegation that became part of the criminal case surfaced regarding the complaining witness finding an alleged threatening note. But even then, 6 more days elapsed after that before ultimately Mr. O'Grady was arrested without incident. And the reason that we bring that up, Your Honor, is that the record evidence here demonstrates somebody who, when confronted with these allegations, availed himself of the legal process available to him in a way that one would hope somebody, for example, on pretrial conditions of release, would use the process and the legal process to try to defend themselves, and bodes very well for someone's prospects on conditions of release. This is not the type of situation where, a complaining witness comes forward to law enforcement, and to present these allegations, and the state immediately responds to utilize the most restrictive measures available to protect public safety. These allegations were litigated over the course of almost 2 months. And again, there is this one allegation that a note was left on June 15th. And separate and apart from that, there's no indications that in the record that Mr. O'Grady undertook any steps to place the complaining witness at risk of harm.
Thank you.
Mr. Davis, leaving aside the issue about the charge regarding the violating the restraining order, there was no question about the drafting of the note or the accuracy of the note, was there?
For purposes of, it actually was.
I'm not talking about anything to do with the violation, but just the note itself.
I think for purposes of the evidence presented at the hearing, the court reached a conclusion that it would accept that the note was what the complaining witness attested it to be. I didn't, for purposes of the weight of the evidence stage, we didn't need to go further with that analysis. Mr. O'Grady would certainly dispute that he wrote that note, but for purposes of the weight of the evidence hearing, the state presented what it had, and the court made a determination about that. We didn't object to the offered exhibits. It's just more of an issue for trial, I think, for him to argue that in fact he wasn't responsible, or he wasn't guilty of that accusation. So we also submit, in addition to the issue of the arbitrariness of the decision, because there weren't findings made as to why our plan, why we failed to meet our burden, that in light of the evidence presented below, it was clearly unreasonable for the court to reach the conclusion it did, that we didn't meet our burden. And I've already discussed the timeline here, but just briefly, in this case, we have all of the positive evidence that we submitted regarding Mr. O'Grady. We have a plan that approximates the tightest set of conditions of release you can have outside pretrial home detention through DOC, which is not available to us under this. And juxtaposed against that, you essentially only have the seriousness of the allegations. And I say that they are serious. They'll be serious in every 7553 analysis. But the court, in identifying the 3 bail factors, and it chose to review them all, understanding the law says the trial court doesn't have to, identified nature and circumstances, weight of the evidence, and character and mental condition of the accused. But all of that essentially derives from the accusations made by the complaining witness. And juxtaposed against the record we put forward regarding who this person is and how stringent this plan is.
You have 1 minute left, counsel. 1 minute.
Thank you, Your Honor. We believe that for the court to credit the seriousness of the accusations to the exclusion of the evidence we presented in determining that we hadn't met our burden, that was clearly unreasonable in this case. And I would yield at this point.
Okay. Thank you very much. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Chief Justice Reiber, Justice Carroll, Justice Cohen, and may it please the court. My name is Darren Raleigh, and I represent the state of Vermont, the appellee in this bail appeal. This court should affirm the trial court's decision to hold the defendant without bail pursuant to 13 VSA 7553. The trial court's decision was not arbitrary. It was based on an articulated legitimate government interest, and therefore the trial court's discretion was not abused. Once there's been a finding that the evidence of guilt is great under 7553, there is a presumptive hold. At that point, there's no constitutional right to bail, and it becomes the defendant's burden to persuade the court to exercise its discretion towards release. Of course, the trial court's
Ms. Raleigh, again, I don't like to interrupt mid-sentence, but looking at the history from Mr. O'Grady of service to his country, 11 years without incident, a longtime employee at a well-established company, General Electric, without any evidence of any incidents there, and no criminal history whatsoever, and other than, then getting into a deteriorating relationship with Ms. O'Grady. Correct? And is that, so how can that be analyzed here in a normal circumstance of a whole without under 7553 life offense?
So, Justice, thank you for that question. There is obviously the presumptive hold once the evidence of guilt has been established, and the trial court did weigh those factors. In fact, they weighed favorably for the defendant in this case, but the trial court relied on three other factors: the nature and circumstances of the offense, the weight of the evidence, and the defendant's character and mental condition in holding the defendant without bail. I do think, and the state submits, that those factors weigh in his favor, but that does not then necessarily lead to the exercise of discretion towards release. The court is able, the language in the case law is very specific, that the court may consider 7554 factors, but the trial court is not required to consider every consideration explicitly, and the trial court's decision ultimately just must not be arbitrary. And that's somewhat difficult because there's not a specific rule for what abuse of discretion is, as this court is aware. But the state would note a number of things that this court could consider in trying to assess abuse of discretion. That the court somehow relied on facts that were not in the record. That didn't occur here. That the court relied on impermissible considerations. The state would submit that did not occur here. That the court applied the wrong legal standard. Again, the state would submit that did not happen here. Or that the court used faulty logic or overextended its expertise. And again, the state would submit that did not occur here. It bears to reason, I think, Justice, that there will be favorable factors for almost all defendants in every 7553 hold without bail argument. If the court is considering each of the 7554 factors, some will be favorable. And the state certainly submits that there are favorable factors for Mr. O'Grady. But the question isn't whether there are favorable factors for Mr. O'Grady's release. The question is, did the court arbitrarily decide to hold Mr. O'Grady? And the state submits that it did not. And in
May I ask you a question, counsel? You mentioned mental condition, and I think Justice Cohen referred to the defendant's service. Is there any evidence in this case of that the defendant is a war veteran, that PTSD is somehow implicated?
Justice, that did not come up during the course of the weight of the evidence hearing. I wouldn't be comfortable speaking to that at this point. The character and mental condition considerations really had more to do with the history of violence as well as the defendant's drinking habits. There was evidence put on about the defendant's engagement in alcohol abuse. that he had a history of alcohol abuse, that on almost all of the occasions where violence occurred, and in fact, I think on all of the occasions that the complainant testified to, both in the course of the RFA proceedings as well as in her conversations with law enforcement, she stated that he had been using alcohol to some degree. In fact, I think that she referred to him as being drunk on all of those occasions. And so I certainly, the state hears the appellant's argument about whether or not the conclusion was explicit within the entry order authored by Judge Valente. The court or the state submits that it is explicit, but that ultimately it doesn't need to be explicit if the court is going through those factors. The law does not dictate that the trial court must go through each of those factors, but the trial court did do so. The trial court's discretion is extremely broad. The state would point to appellant's argument about the availability of Mr. O'Grady's mother as a condition 4 person. The trial court did state explicitly that it found Ms. Sullivan to be genuine and sincere. Just because Mr. O'Grady had a condition 4 person to offer to the trial court does not necessarily conclude that he should have been released to her custody. The trial court also weighed against that release his character and mental condition and the recency of violence, the history of violence, and the fact that Mr. O'Grady was living with Ms. Sullivan at the time that occurred. And that's not to say that living with Ms. Sullivan counted against her as though her obligation had applied before she was a condition 4 person, but that Mr. O'Grady, the defendant, didn't stop having contact or participated in the violation of the abuse prevention order that's alleged in the information when he was living at Ms. Sullivan's residence. In reviewing the trial court's decision for abuse of discretion, this court would have to conclude that the trial court acted without any sound rationale and that the presumptive hold on a life offense in this case is totally baseless. The assertion that the trial court abused its discretion is equivalent to saying that the trial court committed a clear error of judgment, and that's just not the case here, justices. The trial court articulated its reasons after weighing the 75-54 factors. That decision was based in reason and within its discretion. The state is respectfully requesting that this court affirm the trial court's decision.
Ms. Riley, does it matter? Does it make a difference that is she done with her time? I can stop.
No, I don't think so. I think there's still time.
Does it make a difference that the sex assault charge, the sexual assault charge, has a mandated life upon conviction? It's not discretionary. Does it make a difference in how the case is analyzed and the severity, or is that just go to the weight of the evidence in this case?
The state would submit that goes to the weight of the evidence, Judge.
Okay. Again, I'm not so sure that question came out as clearly as I intended, but I'll take the answer. Thank you.
Thank you.
Okay. Does the appellant have any time?
Appellant has 41 seconds remaining.
Counsel?
I have nothing further, Your Honor. Thank you.